This matter comes before the court at this time essentially for a status review. The court notes that there was a court proceeding back on March the 3rd. The court did ultimately take an issue under advisement, the issue of personal property value offset against a $45,000 judgment. The court has issued a decision entitled Order Ruling and Judgment regarding household goods and furnishings that was filed in the court on March 2025. So I will inquire with first, Mr. Potter, are there any other issues before this court that further hearing needs to be scheduled on or taken up today?
I don't believe so, Your Honor. I can advise the court from the last hearing. Jordan has the property listed with Cindy Carnahan as the realtor, and he has had an estimate provided to him by Burns Home Improvements for contracting work for repairs and some other issues with the house. That is $52,000 that he's going to pay so that he can get the house taken care of and then marketed. I provided that to Mr. Olson earlier this week, and so I think Jordan is in the process of getting the house listed for sale.
All right. I do note that under the terms of the decree in this case, upon Charity moving out, the property was immediately to be sold. Immediately essentially means generally without delay. Mr. Olson, is your client satisfied with the progress that Jordan is making on getting this property not only listed, but readied for sale?
Well, I guess if I may inquire, sorry to answer your question with the question, Your Honor. Mr. Potter, Mr. Potter did send over the estimate, I think on Monday of this week, so I've had it well in advance of the hearing, but I guess I'm not understanding if Mr. Phillips is going to be requesting an offset from my client, or if there's going to be an additional request of the court that this estimate be split or subtracted from the $45,000 payment that he owes to my client. I guess clarification on that would assist us in how we move forward. And then to answer the court's question, I mean, it does take time. I'm assuming Mr. Phillips wants to maximize the value of the house. So, you know, again, we're getting into the time now in the spring that I think is the quote unquote hot time of the year to list homes for sale. So we were hoping and anticipating that be done here in the next couple of weeks or whatnot. But again, I think the first question would help us at least understand what we potentially may have issue with or what we do moving forward.
All right. I think it's a fair question. To answer the court's question, Mr. Olson, first of all, the court would just make the observation in the view of the court, it's not Charity Hahn's responsibility to subsidize updates and improvements that would enhance market value. Now, I don't know if that's what's going on here, but that is often the case, especially on high-end properties. Second of all, I've looked at the language in the decree, anticipating this issue might eventually come up. Quite frankly, the language of the decree, which is in place in this case, states no duty to preserve the real estate property in any defined condition. There's no definition or even suggestion regarding ordinary wear and tear and what that would mean in the context of this case, nor is there even some general, as attorneys often try to do, reserve jurisdiction of the court on any and all matters dealing with the fairway property not set forth herein. None of these clauses exist. Therefore, in the view of the court, there is nothing in this decree involving this property for this court to either construe or enforce. Therefore, if there is some legal right or remedy that Jordan Phillips has, he can pursue it, just not in this case. There's nothing for this court to act upon in this regard, because I have no provision in the decree to enforce. Therefore, I can't really answer the question other than that, Mr. Olson. Anything else, you just need to talk to Mr. Potter about.
Okay, and that clarifies, Your Honor. I appreciate it. On that note, then, I don't think we have any issues with the little bit of delay that's occurred as the house is not yet listed, and I do understand the provision of the journal entry of judgment decree of paternity. The only housekeeping items that we have, Your Honor, is Mr. Phillips was slated to pay $71.34 in child support beginning this month, April 1st. He's only paid $3,000, which was the prior obligation that he had. The court already referenced, but there's a court order with respect to child support. We filed a motion in November of last year. The court did retroactively modify child support dating back to January 1st, and then the court outlined in its prior order that Mr. Phillips was going to pay an additional $2,032 per month for April, May, and June to get caught back up. So there's where the $71.34 comes from. That payment has not been made in full. So we would request that immediately be rectified and fixed as soon as possible, if not today. The other part, Your Honor, is if the court would recall, there's provisions in the same journal entry for reimburse. Well, there's not provisions. Mr. Phillips was to pay the utilities for the home. My client ended up covering those. Mr. Potter and I have already worked out through an agreed order reimbursement for the utilities. There were 2 installment payments that were to be made to Ms. Hahn. Mr. Phillips has already made installment 1 payment, but he has not made installment 2. The second installment payment is $19,951.94 for utilities that my client has paid. That has not been paid either. Again, we would request that be done as quickly as possible, if not immediately, because again, these are amounts of money that my client's paid out of pocket, and we've already agreed upon the reimbursement. It just needs to be taken care of by Mr. Phillips.
All right, Mr. Olson, when was the $19,000 installment actually due?
I would apologize, Your Honor. I'd have to go back and look at Mr. Potter and I's agreed order.
The order says that it's
In the house. Okay, and I maybe made a mistake there. Sorry, Tony. Go ahead.
I'm sorry, I didn't mean to interject. I know what the order says. It says it needs to be paid from the proceeds of the sale.
Okay.
Okay.
And I didn't have that clear. I apologize.
All right. And I'll also note, Mr. Olson, that his obligation is to pay this enhanced amount during the calendar month of April. The court doesn't define it by particular date. If he makes the rest of the payment by April the 30th, he's in compliance in the view of the court.
Understand, Your Honor.
Of course, I would expect that it would be made fully by April the 30th.
It will be, Your Honor. I'm sure it's just an issue of communication with accountants and things, and just to make sure that we're all on the same page. The utility issue was ongoing over 7 years, and unbeknownst to Jordan, so we're trying to correct that issue as well. I appreciate the court's comments as far as the information that's in the decree, and I understand what the word immediately means. Unfortunately, I wasn't involved in drafting this order, and so we're trying to take into account when the property was vacated, Jordan's work, and getting all of those things coordinated. I believe that he is trying to be proactive in getting this done. I don't feel like there is any delay, but I certainly can review those issues with him. As the court can see now, he's joining us, so it's not that he's turning a blind eye. I think that probably my office sent him the wrong link for today's hearing, so I know that we are moving forward with the case.
All right. Obviously, you haven't listed with a realtor. I'm sure that Jordan will be following the realtor's recommendations about how to get the best possible price. And it also might, if improvements to the property are made, it might actually facilitate a prompter sale, which benefits everyone.
I would assume so, and I think that is his plan. Correct, Your Honor.
And I have no doubt that Mr. Olson will carefully monitor this situation and bring the matter back before the court if he is dissatisfied with the progress that's being made.
Okay.
Yes,
I do
sir.
appreciate Charity's patience as Jordan attempts to get the property ready for sale and actually selling it. All right. Good luck to the parties in that regard. Mr. Olson, anything further?
No, it's time, Your Honor.
Mr. Potter?
No, Your Honor.
Very well. And if there's nothing further, the Hahn and Phillips matter will currently be in recess, and this meeting may be ended for all at this time.
Thank you, Your Honor.
Thank you, Your
Thanks,
Honor.
Tony.